Welcome back to CLTV News. We're talking a lot about the Laquan McDonald case today, and joining me now on set is Antonio Romanucci. He's a civil rights attorney based right here in Chicago, and he handled the case for Latrice Wilson in 2007. Chicago police shooting at Latrice 24 times, actually hit 18 times, and the city settled out of court for $4.5 million.
Good morning.
Good morning. Thank you. Yes, I wanted to get that out there. So you've been down this road before.
Been down this road before, and really I was quite shocked when we started hearing about Laquan McDonald, because once again we have a Chicago police officer who's basically unloading their gun into a civilian. That really shouldn't happen. Clearly, if there's a need for it, there's a police officer can stop somebody who's committing a crime, or if there's deadly force required. But this appears to be now more of a pattern, because you've got the Latrice Wilson case, you've got the Flint Farmer case, which was just several years ago, and that was another case where a police officer unloaded an entire clip plus one in the chamber. Now you have Laquan McDonald.
So is this, when we talk about the use of deadly force, and I know as a civil rights attorney you would know a lot about this, is the goal to just deter the person from whatever they're doing, if they're not abiding at the time? What's the goal when you apply deadly force? I've heard it's shoot to kill. A lot of people are saying he didn't have to unload his clip plus one on Laquan McDonald. What's the goal?
Well, and we should use Laquan McDonald as the example right now, because we have it on video. So Laquan, at worst, was either walking away from the police officer or in a neutral position. There was no lunge, there was no furtive movement, as they like to say, there was no shoulder turn, there was no pointing of a weapon at that police officer. At that moment, the law says you are not to use deadly force. That's where you use less than deadly force to stop somebody who could or might cause harm to somebody. Now, in the alternative, if somebody is pointing a gun and making a movement towards a police officer, that could be an exception, and that could be a good case of use of deadly force. Now, police officers are taught to do what's called a double tap, which means if they're going to stop somebody with use of deadly force, they're going to shoot at least twice.
Okay.
You don't shoot once, because if it's really a threat, you want to stop the threat.
Okay.
However, in this case, you can see quite clearly Laquan was on the ground,
right,
and you see bullets flying and striking the ground. What use of force was necessary to stop somebody who was already on the ground?
Are we just looking at a trigger-happy cop? Maybe a cop that's gone through PTSD? I just don't understand if he was a backup cop, one of 8 backup officers. You get to the scene, you're not even there 30 seconds, and you unload an entire clip plus one on the 17-year-old who was walking away. Now, he did have a knife. It was important to mention that, but like you said, it wasn't a threat. He wasn't pointing it at anyone. He never lunged at anyone. What do you think was going through that officer's mind?
I think that's a great question, and I think the answer is twofold. Number one, it's the culture and the accountability that doesn't exist in the Chicago Police Department, and number two, it's lack of training. If that officer was trained to identify what a threat was, what a threat to himself was, or a reasonable police officer in that situation, Laquan would be alive. That would not have happened. He would have been taken down with other means. Maybe a taser, maybe a beanbag, maybe
and supposedly
a baton strike.
No one had a taser on the scene. I guess that was something that was discussed by Anita Alvarez yesterday.
Can you believe that? Can you believe that there were 8, 9 police officers on scene and not one of them was equipped with a method to take down a suspect with less than a gun? That's hard to believe. That's training. Or is that funding? Is that lack of equipment? Whatever it is, it's bad.
Do some of the details of this case sound fishy to you? Especially, we talk about it took a year and some change to even file charges against this officer, and that only came after the video was supposed to be released. I mean, just some of the details that we've heard in this case, as a civil rights attorney, does this sound fishy to you?
Oh, it certainly does. I mean, it doesn't seem appropriate. That video is public. It should be available to the public. It was filmed on public camera. We pay the Chicago Police Department. It should have been released when it was asked for. And it wasn't, and It certainly, I mean, it smells of political issues that it wasn't released sooner.
That the city was trying to cover this all up.
Absolutely.
And is that the reason why you think the settlement came about? A $5 million settlement toward Laquan McDonald's family. Now, because they've settled, they cannot sue the city.
Well, let me answer it this way. In the Latrice Wilson case, in the Freddie Wilson case, where there was no video, so without the video, we could only rely on what the police officer said. We had to reverse engineer that case in order to prove that what the police officer said was either false, inconsistent, or not accurate. With the video tells the story.
Right.
What they tell you the night of the shoot does not match up with what the video said. That's why it's so important for the public to see the video. Despite what people say, the court of public opinion, and don't decide this case from your couch, we have the right to see the video. We have the right to make our own decisions as to what happened.
And do you believe, you know, especially with the Latrice Wilson case being settled, $4.5 million with no video, then Laquan McDonald's case, $5 million with a video, do you think if the family had moved forward with a lawsuit, they could have gotten even more out of the city of Chicago?
Well, it's hard to say whether they would have gotten more, but I think had they moved forward with a lawsuit, and I'm not criticizing them for settling before the lawsuit, but you need to get accountability. Without a lawsuit, you don't get a judgment.
That's
and
true.
Without a judgment, somebody's name doesn't go in those permanent record books.
But
right?
then you consider the fact, okay, so now we have charges from the state's attorney in Cook County, and then also there's a federal case in the works, is our understanding. True. So, but do you think these cases are a slam dunk?
You mean on the criminal side?
Yes.
Oh no, they're not a slam dunk.
Even with the video?
Even with the video, because there are laws that protect police officers in those situations. So if it was you and I as a civilian, that's different if they catch on video. Police officers are granted very special immunities in situations, so you have to prove a reasonable police officer standard. So they're not slam dunks. Now with the video, it certainly does help a lot. Okay, it certainly does create that room to make decisions which are easier, but it's still not easy. You know, Anita Alvarez does have a difficult time with this case. It's not a slam dunk, even though you would think it is. In a civil case, it's a much easier case to prove.
Okay.
In a criminal case, it's harder.
But the civil case is now out the door.
Civil
no way
case is over.
They can move forward with that.
It's done with that.
Antonio, thank you so much for your insight.
Thank you so much.
We really
appreciate it.
having you.
Thank you so much for having me.
No problem.